Hi, Attorney Steve Vaughn, and we're back, the real estate lawyer, and we're talking in this video about the writ of attachment in financial elder abuse cases in California. Okay, so we're licensed practice law in California and Arizona. One of the practice areas that we get involved in is financial elder abuse, taking money or personal property of elders in bad faith. So let's talk about this very, very powerful weapon in the litigator's toolbox when you're litigating these cases, okay? So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, so we're talking in this video about the writ of attachment, okay? And where you're gonna find your financial elder abuse laws, you're gonna find it coming under the Welfare and Institutions Code, section 15657, okay? So it may seem like a strange place to have a financial elder abuse statute, but our main statute can be found at Welfare and Institutions 15657. Okay, so what happens is you get involved in a complaint, you file the complaint, and of course the defendants are running scattered, denying everything, saying it couldn't be a shred of truth to this, I did my job, I upheld my fiduciary duties. Sometimes it's a lawyer you're going after that basically ripped somebody off, gave bad advice, just abused them, charge them exorbitant, crazy fees, real estate brokers, insurance brokers. I mean, all kinds of things pop up in the area of financial elder abuse. So let's talk about it here. So the first thing you're going to have is you're going to be dealing with filing your complaint. Obviously, that's the first thing you're going to do in every civil litigation case. First look to see if there's any arbitration clauses, then go right into your civil complaint if not, okay? The complaint must allege a cause of action for financial elder abuse. Don't accidentally leave that out. That's what you're suing for. You cannot go and seek the writ of attachment for most other causes of action. I believe it's also available for a breach of contract, but make sure you're getting your cause of action in there for financial elder abuse, articulating each and every element of the count. And we've had other videos on pleadings. So, but anyway, make sure you get your cause of action for financial elder abuse in there. Let's check that off. You want to have an ascertainable amount in dispute when you go for these writs. So in other words, you want to have some sort of finite number that you're looking to get. Don't just say I'm looking for $20 million, throwing some giant number out there and expect that the court's going to buy that in regards to your writ of attachment. So have some realistic, ascertainable amount, okay? That's checkbox 2. Pleadings, verified. You may want to verify your pleadings. If you don't know what that means, it means that you're certifying under oath that every allegation in your complaint is true and correct to the best of your knowledge, okay? So you may want to verify your pleadings. Why? Okay, and you'll see when we get to the writ of attachment, which is the next stage, that you're going to need some verifiable admissible evidence. By putting this in a verification format, a verified complaint, as your attorneys, you go through it painstakingly and get these facts down. Make sure you know your facts are right and they're not going to change. But that allows you to get some evidence when we come over here. We'll talk about that in a minute. So that's your complaint. That's the complaint process, the things you want to keep in mind when you're filing the complaint. Now, let's move to the next stage, which is the actual filing of the writ. The filing of the writ you can do at any time. I mean, you don't have to do it after you file the complaint, but you can do it. You can wait into the litigation a little bit to make sure your facts are right. You can wait till you go through the discovery process a little bit and see what the information shows. Make sure it's verifying what you're saying is true. Make sure you know you got them. Make sure you have some evidence you can show the judge that's going to be hearing your writ. Okay, so let's talk about it. These writs are largely a product of the Judicial Council forms. So if you're wanting to get an idea of these forms, you can go to seniorcareattorneys.com. That's our website for our financial elder abuse, seniorcareattorneys.com. Go down to the writ of attachment. There'll be a blog there with all the forms. But you'll see the forms AT 105, 125, 130, 135. So the forms are already pre-made for you to help guide you through the process, to get you thinking about the things you're going to need to make sure you get in there, okay? But I just want you to know it's Judicial Council forms. Now you have your writ, okay? So I drew my W here. That's our writ, okay? So we're going to be filing a writ with the court. Okay, you always want to find out first and foremost what court you're in. What days do they hear these writs? Okay, are they on Tuesdays? Are they on Fridays? Are they at 2 o'clock? Find out before you do this, but you want to find that out. So you got your writ. You're going to be looking to attach personal or real property of the defendants, one or more of the defendants, and sometimes you may sue 4 or 5 defendants, and you say, well, I've only got the goodies right now, the good, firm, solid proof on 2 of the defendants, so go after 2 of the defendants, okay? But you're going to be seeking the personal or real property, cars, trucks, autos, boats, bank accounts, real property that may be located in 1 or more counties. So you're going to want to do oftentimes an asset search. That's something that we do, is an asset search to find out what these defendants own, what their assets are, okay? Those are the things you want to be attaching, okay? Now, you want to make sure, I'm going to put here, name match, okay? You see that? That's very important. So when you do an asset search, you're going to want to make sure that the assets that come up and the names that you're putting in your writ, that they match completely. So if it's David R. Jones, don't put Dave Jones, okay, because it's not going to work right. You need to treat these as if they are a summons, where it has to be exactly the same name on your assets. And if the property's held in David R. Jones, you want the name match David R. Jones, you know, that sort of thing. So you need to be exact, because otherwise you're going to spin your wheels. Direct these, what we call the right to attach order is one of the documents that you're going to be submitting. Your right to attach order is part of this package. Okay, your whole writ thing here is a package that you're going to be submitting to the court with all your materials. Okay, so it does take time. Usually you have to take a full day to get to the bottom of this and really make sure you're going at this very meticulously to make sure you have that. So, okay, you're going to direct this at the sheriff, because ultimately it's the sheriff that's going to go do the levying on the property. So you're going to direct these to the sheriff. If you have property in more than 1 county, sorry, I just messed that up, but if you have properties in 1 or more counties, you may need several writs, because you may need the sheriff in 1 county, in Los Angeles County over here, San Francisco County over here, Maricopa County over there, and Orange County over here. The defendants may have property all over the place, so you're going to have to look carefully at that and take your time. Now, also with your package, so you're going to identify with specificity the personal or real property that you're seeking to attach. You're going to attach any admissible evidence. Let me say that again. Any admissible evidence, something that would be admissible in a court of law, something that a foundation can be laid, something the judge can actually sit there and flip through and say, okay, this is evidence, certified. You've got declarations of the plaintiff, you've got declarations of the attorney, you are laying foundations for the admissibility of the evidence. So you want admissible evidence attached. So you really, as you see, you really need to take your time to put together a nice package with all your evidence, so you make sure you're not wasting your time when you get that day in front of the judge. And again, there's your declarations, okay? So that's the beginning part, the complaint requirements, the writ requirement. In your writ, questions that we get sometimes, well, what kind of damages can I be seeking to attach? Well, add it up, okay? So what you want to do is you want to add up all your compensatory damages that you can prove, your attorney fees and costs, and also punitive damages, okay, using a reasonable multiplier. Don't get crazy and say, I'm going to get $100 million in punitive damages. Don't go down that road, but just say, I want a reasonable multiplier, 3 times, 5 times, 10 times, something that could actually be upheld in a court of law. So that's part 1, coming right back with part 2.